The day I realized something was wrong was the day I found a city-grade future community improvement sign staked into the mud at the edge of my pond. Not near it, not adjacent to it, right in it. That pond has been on my family's land longer than the road that leads to it. My grandfather dug it by hand in the early 1950s, back when this valley didn't have a name, just fences and mile markers. I grew up fishing bluegill there, learned to swim there, scattered my father's ashes on the far bank when he passed. It's not decorative, it's not recreational, it's part of the land, and it's always been private. So when I saw that sign, I thought it had to be a mistake. I pulled it out of the mud, tossed it into the bed of my truck, and drove up to the house to make some calls. That's when the HOA president showed up. His name was Gerald Huxley, mid-50s, trim beard, always dressed like he was headed to a zoning meeting even when he was buying feed at the co-op. He lived 3 developments over, in a subdivision that didn't exist when my family was already paying taxes on this land. He parked his Lexus right across my gate like he owned the place. "You can't remove posted notices," he said, before I'd even shut my truck door. I looked at him and said, "You can't post notices on land you don't own." He smiled like I'd just said something adorable. According to Gerald, the HOA had assumed stewardship of my pond as part of a new water access initiative, something about shared environmental resources. He said it slowly, like he was reading from a brochure. I told him he was standing on private property. He waved a hand. The pond feeds into a watershed that services the development. That makes it a shared asset. I asked him if he'd like to see my deed. He told me I didn't need to get defensive. That was the first red flag. Within a week, survey stakes appeared along my fence line, then orange ribbon, then another sign, this one announcing a future community fishing area. I started getting letters in the mail, HOA letterhead, warnings about obstruction of access, notices of non-compliance, a $250 fine for removal of HOA property. I drove to the HOA office and laid my paperwork on their front desk. The clerk didn't even look at it. "Talk to Gerald," she said. Gerald refused to meet on my property again, said it was no longer appropriate. Instead, he summoned me to a board meeting like I was a child being called into the principal's office. I went, calm, quiet, brought copies of everything. At the meeting, Gerald stood up and addressed the room. "Some landowners are having trouble understanding community integration," he said, looking straight at me. "We've tried education, now we'll try enforcement." I raised my hand. "That pond is not in your development. It's not under your charter. It never has been." Gerald clicked a remote and a map appeared on the screen behind him. A thick blue line outlined the subdivision boundary. My pond was shaded inside it. He said, "This says otherwise." I stood up and walked closer. That map was wrong. Not mistaken, wrong. The boundary line had been redrawn. I told him so. He shrugged. "Updated survey." I asked who commissioned it. He said the association. I asked when. He said recently. The board voted unanimously to proceed with the project. Gerald announced that construction fencing would go up within the month and any interference would be treated as a violation subject to escalating fines, liens, or further action. After the meeting, he stopped me in the parking lot. "You should consider selling," he said. "This area is changing." I told him I wasn't going anywhere. He leaned in close and said, "We'll see." 2 weeks later, a certified letter arrived. Notice of intent to impose a lien, failure to comply with HOA directives, unauthorized obstruction of community access. I sat at my kitchen table and read it twice. That was the moment I realized Gerald hadn't made a mistake. He'd made a move, and he'd picked the wrong person.
I didn't call a lawyer right away. First, I called the county. The clerk in the recorder's office knew my last name before I finished saying it. My family's filings went back generations. She pulled the original land grant, the 1948 survey, the amended deed from when my grandfather dug the pond. She frowned when I showed her Gerald's map. "That boundary was never approved," she said. "And that stamp," she leaned closer, "that's not ours." That's when I called an attorney. His name was Thomas Reed, property law, quiet guy, grew up hunting 10 miles from here. He didn't say much when I explained the situation, just asked for copies of everything. When he saw the map, he whistled low. "They didn't just overreach," he said, "they fabricated jurisdiction." He filed an injunction within 48 hours. The HOA responded by doubling down. They sent contractors anyway, put up temporary fencing, installed a gravel access path right through my lower pasture. When I confronted the crew, they showed me paperwork signed by Gerald authorizing entry. I told them to leave. They said they couldn't. So I called the sheriff. Deputy Morales showed up, took one look at the deed, the fence line, the pond, and the map. He turned to the crew and said, "You're trespassing." They packed up fast. That's when things got serious. The HOA's attorney filed a motion claiming adverse control over shared water resources. Thomas countered with historical surveys, aerial photos, tax records, and affidavits from 2 retired county surveyors. Then Thomas found something else. The updated survey Gerald had presented? It was never conducted. The firm listed on the document had dissolved 8 years earlier. The signature belonged to a surveyor who died in 2016. We took that to the county prosecutor. An investigation opened, then another. Turns out Gerald had submitted the altered map to 3 different agencies: planning, zoning, environmental review. All of them accepted it because it came from an HOA with a clean record. Until now. The court hearing was quiet, no theatrics, just paper and patience. Gerald sat at the defense table, jaw tight, hands clenched. The judge flipped through the exhibits slowly. Original land grant, tax rolls, certified surveys, the forged map. When the judge asked Gerald to explain the discrepancies, he stood up and started talking fast, too fast. Claimed misunderstandings, claimed delegation, claimed good intentions. The judge held up a hand. "Mr. Huxley," she said, "this document bears a forged signature." Silence. The court finds that the plaintiff retains full and exclusive ownership of the pond and surrounding land. Further, this matter is referred for criminal review. Gerald didn't look at me when they escorted him out. The fallout was immediate. The HOA board dissolved within a month. 2 members resigned. 1 turned state witness. Gerald was charged with fraud, falsification of records, and abuse of authority. The county invalidated every project approved under his tenure. As for me, the lien was vacated, the fines were erased, the fence came down. One evening, a few weeks later, I walked the pond at sunset. The water was still, the frogs were loud, same as always. I sat on the old wooden bench my father built and watched the light fade off the surface. Land doesn't forget who tends it, and paper trails don't lie forever. Sometimes standing your ground is quiet. Sometimes it just takes time. But justice has a way of finding its way back to the water.